Welcome to a preview of this year's Changing Currents in Employment Law, the DC Bar's Employment Law CLE on October 27th. We are here today with Ariail of Holland and Knight and Lauren Khouri of Correia and Puth, talking about one of our panels, Pandemic in the Workplace, Preparing for the Next COVID-19. We know that during this pandemic, that employers were not ready. Will employers be ready for the next pandemic? Let's ask our panelists. Kara, what do you think? Next time, are employers going to be ready for the next emergency, the next pandemic?
I certainly think they'll be much more ready than they were this past time. And I think that a lot of the policies that I know we're encouraging our clients to put in place, a lot of the issues we're encouraging our clients to look at, things that we're really going to be talking about in our presentation, should better position employers to pivot more quickly next time into the types of situations that are required, temporary telework, managing accommodation requests that are a little outside your usual ADA and those kinds of things. So I do think that as stressful as this has been for employers and employees, it is going to give us some groundwork that we can build on when this comes back again.
So Lauren, what do you think? Do you think that this is going to change the workplace fundamentally for employees in the future?
I think so, Scott. I think I could safely say that in our lifetimes, we haven't dealt with something like this before, where we've had to see the workplace shift so dramatically and so quickly, regardless of whether you were an essential employee or an employee who moved to working from home or an employee who experienced a furlough. This was a major shift. And as Kara said, I think when it happens again, we'll at least know what to expect because we've done it before. I think we will see some, really seismic shifts for some employers, but there will be other employers that probably go back to business as usual if they're not already there.
So Lauren, what are you telling employees who don't want to go back to work? Let's say, the employer says you need to come back in order to have your job, and they're scared. What kind of advice are you giving them?
Yeah, honestly, that has been the hardest question that we've been confronting during this period of time, particularly now that people are going back into the workplace. Some of it's shifting so that not everyone is working remotely. So the excuse that an employer is being unreasonable by asking people to be in the workplace, it looks different today. So our first questions are questions that maybe we would have asked before too about, do you have a disability? Is there something about your either working environment or personal circumstances that make returning to the workplace difficult, and helping to craft a request based on those issues. And for others though, unfortunately, I think we've seen a lot of employees who are between a rock and a hard place because, what Kara said about businesses being flexible and us having flexible work environments, that would be the gold standard here, because the reality is just that the law doesn't allow for employees with no medical condition, with no childcare condition, with no, a ton of other issues aside, which, of course are at play here, to pick and choose their workplace.
So, Kara, it sounds like some of our leave laws that were enacted by Congress have some holes in them. What kind of advice are you giving to employers who want to bring back employees, but their employees are concerned about coming back?
Right. Well, Scott, you've heard me probably say this a bunch of times over the years. I think that, one of the surest paths to litigation is having a workplace where the employer is perceived as disrespectful or unfair. I think that's a bigger risk, frankly, than not complying with the employment laws a lot of times. So, of course, as Lauren said, you need to run to ground any applicable laws, ADA or other accommodation laws, FFCRA, if that's applicable. But I think, I'm really encouraging clients to really think about what the need is. There's a difference between just wanting someone to be in the workplace because of the benefits of collaboration, which is a very real benefit, and then whether that employee is actually not able to fully perform their job remotely. And I am encouraging clients whenever possible, if you can be flexible, if you can provide that ongoing remote work, that's the best way to go. Not because that's your obligation legally necessarily, but because if the employee feels that their concerns and anxieties are heard and respected in general, that's going to be better for workplace morale, the employees' morale. And so that's a win-win for everybody.
And if an employee gets sick and has to miss work, right? And they say, look, I want to hold my employer responsible for what happened to me. What kind of advice are you giving to employees, Lauren, in that situation?
Well, we've seen a real rise, or I mean, maybe just a creation because these types of waivers didn't exist before, but, a rise of waivers in the workplace where employers are looking for their employees to waive liability for COVID if they were to contract the virus while they were at work. But, from our perspective, those waivers are inappropriate because, we feel like the law builds in what an employer needs if they're doing the right thing. If an employee catches COVID while they're at work and the employer provided masks or gloves or had an air filtration system or whatever is appropriate for that workplace and had done their due diligence, then the employer will be protected from liability. So it for employees who are afraid of contracting the virus or who have actually contracted the virus, and we've seen a few examples of employees where they believe they caught it in the workplace. Our first question is about, well, what did the employer do to ensure that you'd be safe in the workplace?
So, Kara, waivers inappropriate?
I absolutely think they are. I am telling all my clients, I don't think a waiver is the way to go. I don't think waivers are enforceable in the employment law context, particularly when the employee is just returning to work to do their job. You can't waive certain safety rights under OSHA or workers' compensation rights and these kinds of things. And what I'm really recommending to clients instead, I call it an acknowledgement of the employer's COVID-19 protocol, for not only to make sure that you're following the recommended health and safety guidance, but also to make sure that employees are clear on what those protocols are and that they have a path to, that the employer essentially wants to hear if something's not going the way it's supposed to, right? People aren't maintaining social distance or wearing masks or whatever the case may be. I think that can only help show that the employer was taking all appropriate steps to prevent the risk or manage the risk at least.
Kara, Ariail, Lauren, Khouri, thank you very much. We look forward to seeing you both at Changing Currents, and we look forward to seeing each of you on October 27th from 6 to 9:15 at the DC Bar virtually. See you then.